Well, this is an official welcome to everyone. Just going to remind Ari that he needs to hit the record button if he hasn't already done that. Perfect. Step one, done. So welcome everybody. Thrilled to have you here at our virtual town hall to talk all things legal as it relates to COVID-19. Thrilled to have you all here and glad that we were able to offer this in partnership with Roper Greyell. And I'll just start by sharing a little bit about Engaged HR for those of you who we haven't had a chance to meet yet. So Engaged HR is a human resources consulting firm here in Victoria, BC, now spread out over multiple locations in Victoria, BC, as we have all our work from home employees. We serve organizations across Canada. We're in every province and territory, serving nonprofits and small to medium-sized businesses with all things HR. So we help organizations create great places to work and are thrilled to be able to connect with all of you today in this crazy time that we're in. So I'm also going to introduce Ari Epstein. So you can see Ari there. He's moderating today and is partner and co-founder of Engaged HR. And you'll also, as you look at various cameras that are on today, you also see a number of the Engaged HR team members on the call today as well. We're also thrilled to be able to do this town hall today in partnership with Roper Greyell, and we have Adam Vanderlyn who's on the call today. You want to just give a wave there, Adam? There's Adam. So you're going to hear lots from Adam today. So Adam is based in Victoria, and we're thrilled to have a local Roper Greyell representative on the island. So Adam is a labor and employment lawyer at Roper Greyell and practicing in all areas of labor, employment, and human rights law. Adam is the firm's point person for many of their Vancouver Island clients. Adam is a member of the Canadian military since 2005 and has provided legal advice to Canadian armed forces across 4 continents. He now applies his skills and experience to workplace law, and we're thrilled to be working in partnership with Adam on the island and here in Victoria as we launch a number of events, but this one in particular today. So welcome, Adam. Thrilled to have you on the call today, and thank you so much for joining us.
Thanks for having me. It's always fun to get an opportunity to talk to people, even though I don't get to see anyone directly in front of me. So I'll just start. I have some opening statements just to talk a little bit about the situation we find ourselves in. Yes, Denise.
I just want to do a couple of tech tips just so that people are clear on how to manage being on the online platform so that it's easier for us as we go forward. So this will just take a sec. So the first one is to mute yourself, and if you want to stay on with your video, great, but also no obligation if you want to turn your video off. If you want to have make a chat, you'll notice that there is a participant button at the bottom of your screen, and you can see who's on the call. If you I don't actually have that now because I'm sharing my screen. Oh, there it is. So you have a participant button. If you click that, you can see who's on the call, and you can raise your hand from that screen if you have a question that you want to ask. And then Ari will be communicating with you one-on-one, and we'll be able to get your question, and then we'll be able to share those with Adam as we go through the Q&A portion of today. You can also, from that same menu bar, there's a chat button, and some of you have seen and been using the chat, which is great. And so as you go through, you can personally send your chat questions to Ari on there privately, and he'll be able to moderate all the different questions that come in. Some of what we might be doing is looking for some themes. So you might word your questions differently, but they're all about the same area. So Ari might be theming some questions and sharing that on the screen with everyone. So then Adam can answer sort of more generally versus specific. So we'll see how that goes over the course of the time together, but we definitely want to try and get to as many questions as we can. And the other thing is just for everyone to know that we are recording today's session, and with that recording, our intention is, we haven't done this before, so we're all new here, but our intention is to be able to share this recording with you after as well, so that you've got if you have to leave early or if you want to share this with people after, that you're able to do that. So I think that's pretty much what I wanted to say. It's going to be really informal. everybody is new to this. We have not hosted an inaugural recorded live virtual town hall on something as important as this. And so we're giving it our best shot. Our intention is to wrap up at 2 o'clock. And yeah, we're happy to have you all here to share the space with us. So I'm going to get a nod from Ari that I'm good to keep going. And now I can pass it over to you, Adam. So take it away.
All
Thank
right.
you so much.
So I'm a little more nervous now knowing that this is going to be immortalized in recording that people can go back and review.
You can waive all liability right now if you wish to put your legal framework in there. You go right ahead.
Yeah. So first thing I'll mention is the first thing that was told to me when I started law school, because it's important for everyone to understand, is that the dean said, you're all going to be studying law, you're all going to be studying to be lawyers. And so everyone around you is going to come to you with legal questions, and your answer will invariably be, I don't know. By the time you're done here, you will know that when they ask you those questions, that you will say, it depends. And so if I'm frequently saying, look, it's contextual and there's a lot of stuff that will go into giving a nuanced answer, I'm not trying to get away from helping, trying to just make sure that everyone understands that there are a lot of nuances with legal questions, and there are a lot of nuances with what's going on in the world right now, especially where it's developing so quickly and we haven't tested most of the answers. So we're having a lot of fun and getting a lot of creativity into it. And then in the coming years, we'll kind of see who was right and who was broke. What we can do, though, is really help you manage the risks that come with these decisions. And so hopefully some of the stuff we talk about today will be useful to everyone in terms of taking a well-measured risk in any of the decisions that are made. So I'll mention, oddly, this kind of format of working completely remotely is not unfamiliar to me. I'm used to working at a distance. As in the military, I spent a lot of time reporting to direct people in Ottawa while being goodness knows where, though oftentimes in some region of Canada, just running that region and reporting to them. So it's kind of nice to see that everybody's getting that experience now and can understand what it's like, because it does create interesting workplace dilemmas. I was just joking a moment ago about the idea of one of my colleagues cutting his hand while cutting an apple. Is that a workplace injury because he's working from home? I fell down the stairs the other day. First time I've ever done that. Is it a workplace injury now? There are a lot of questions that we don't know, and we don't know how far things will go. And this really is new territory. It's uncharted, and we're trying to figure it out. Nationally, there's the Quarantine Act that has now been called into application. So we've gone from the idea that it's a good idea to protect those around us and we want us to do it, please do it, to there are pretty harsh criminal penalties if you don't. Saskatchewan, Ontario, Quebec have closed all non-essential businesses through governmental orders. Washington State this week put in place an order for shelter in place. So they're following a lot of the Italian approach, where it's very restrictive. We have yet to see what BC will do in the coming days, weeks, hopefully not months, but I suspect it will be, in order to manage the risk and the spread of the virus. So what I'll say is, one thing that is clear is after this all falls out, there will be litigation. People will be alleging breaches of privacy because workplaces might have shared their information in order to provide information to other workers that they may have been exposed to the virus. There will be allegations of wrongful termination. There will be suits by people who got sick or, in worst case, people who had a loved one die, especially in cases where workers are masking the symptoms and coming in and exposing others. I suspect that in Ontario, all of these litigations will be more prevalent simply because of the nature of the legal sector there. They tend to be more litigious, but it doesn't mean we won't see our fair share in British Columbia. I want to talk very briefly about just a couple of things that everybody is likely interested in. So employer responsibilities, new WorkSafe basics have really gone a long way, and anyone who hasn't looked at WorkSafe should go and look at it, because some of the things they're suggesting are not particularly doable, but some of them are incredibly doable. And one of the things that they're putting in place is something that if anybody's putting a policy in place to deal with epidemics or COVID-19, should really consider. WorkSafe is suggesting that anyone with COVID-19 like symptoms must self-isolate for 14 days. Anybody who's traveled internationally must isolate for 14 days. Workers who share a residence with a person who has been exposed to COVID-19 must isolate. So these are things that WorkSafe is telling us. It's not quite the same as the government coming down with a mandate, but it's fairly close. These are very good guidelines to take. In terms of employee rights, because wherever there's an obligation, there is a right. There are provincial and federal guidelines, a lot of which have been expanded. The Canada Labour Code has come out with some new policies. I'm not going to address the federally regulated things here. It's my intention to kind of keep this BC focused. So I'm really looking at the provincial stuff, but the Chief Medical Officer order regarding cleanliness and absenting yourself from work if you're symptomatic. Employment Standards Act has come out with a new type of leave, a COVID-19 related leave, and it's remarkably broad. It allows employees to take unpaid leave for as long as they qualify for it. So as long as there's someone sick in their household, someone vulnerable in their household, as long as they themselves are sick, suffering from symptoms. So it's incredibly broad. And along with that, because there's now a leave, they've said, hey, anybody who was terminated for, so their job was just ended because of COVID-related issues, the employer now has to go back and offer them re-employment and put them on the leave if the employee wants that re-employment. So there are some pretty big questions of how far-reaching is this? What are the costs going to be to everyone? And what are the effects of going on this unpaid leave? Another question in terms of employee rights is we have a right to a safe working environment. I fell down the stairs because my coffee, water, wine are all upstairs. These are pretty essential things for me to get through the day. Is it reasonably foreseeable for my employer that I may be trudging up and down the stairs and potentially falling? Okay, am I taking it a bit far? Perhaps, but these are the questions that will be asked. So an employee has always had the right to refuse unsafe work, but that refusal has to be based on a reasonable belief that there's an undue hazard. So again, it's contextual. How big is the risk? I'd suggest that right now, if an employee chooses not to come into work because they're fearful of the hazard, I don't think that they'll meet the test for an unsafe work environment in most cases. And there's some good tribunal and case law history on that. But I suspect that in many cases, and most in fact, right now, they won't be meeting that. So, just simply choosing not to come in because you don't feel safe, unfortunately, isn't going to get you there. EI has changed a fair bit, and I'm almost done with my spiel. So they've waived the waiting period, which is great. But in order to apply, you still have to have 7 days off work. So they'll be backdating your initial payments, but EI is there. In terms of EI coding, that's all up in the air because you have to indicate on the EI what the reasons are. What I can suggest immediately off the bat is don't put any comments. As soon as there's a comment on that form, it has to go to an actual person to be reviewed. It can't just get chunked through the system. So if there are comments, it'll slow everything down and create delays. And given the sudden rise in numbers of people applying for EI, those comments could potentially slow things down dramatically. But, if you're quarantined, it's pretty clear that it's code D for illness or injury. If the business is closed, it's a shortage of work. The less clear one is the effect of the COVID-19 leave of absence, because you likely aren't eligible for EI benefits, though you would get the brand new Canada Emergency Response Benefit, CERB, which replaces the previously announced Emergency Care Benefit and Emergency Support Benefit. So as I said, things are moving really rapidly. The government comes out with a plan, and then a couple of days later they say, you know what? We kind of jumped the gun on that, and here's a better way of doing it. Here's our current plan. But I think we're reassessing everything on a daily basis. I spent most of my morning, as I spend most of my mornings and evenings lately, just making sure I'm up to date on all of the new nuances. So I guess the one thing with the CERB, that emergency response benefit, is it's $2,000 a month for 4 months, which is great, but you can't get it at the same time as EI. And the government is saying, if you're currently drawing EI, please don't apply for it. If you haven't applied for EI, apply for the CERB. And then if you need stuff at the end, apply for EI. If your EI runs out, then apply for CERB, but you can't do both at once. Similarly, there's the question of top-ups, because a lot of employees make more than that 500 and something or other per week. And so going on to EI is a huge pay cut. So employers are looking at sub-plans, that supplemental unemployment benefit. So clearly the sub-plans haven't been updated in a while because they still haven't changed it to employment benefit. But these plans can go in place. Everybody has kind of a vague idea they exist, because this is how we top up people's pay during maternity and paternity leaves. But we don't tend to use them for other contingencies. So now employers are looking at using these plans to top up people's pay while they're off, so that these people aren't losing their houses, losing their cars, defaulting on other loans. But the question is, how far can it be backdated? And so far, the best of our information is once it's approved, it gets backdated to the date that you applied for it. So anybody who's looking at that, apply sooner than later is, I guess, where we are. Otherwise, any additional payment to an employee, if you're trying to help your people out, be careful, because it'll probably result in a clawback. The risk of somebody making a complaint is probably fairly low, but it would result in a clawback if you're topping up without that sub-plan, or if you're providing a gratuitous payment, or any kind of things beyond the continuation of benefits. On the note of benefits, anybody who is looking at continuing benefits for employees who are not currently at work, you should probably contact your benefits providers, because some of them have been updating and others have not their policies. And they're suggesting that after 30 days or sometimes longer, if the employee's been on a leave of absence and unpaid, or if they've been on EI, then they will no longer be covered under that group benefit plan. So you want to make sure you reach out to your benefit provider for the sake of your employees who may not be there. I guess last thing I wanted to just mention is the broad list of essential services. We have an essential services list that covers pretty much everything but entertainment. So right now, the government has just put in place directives to enhance the government control. But what they seem to be saying is that if you haven't been specifically ordered to close, like pubs or casinos, then as long as you can comply with social distancing and the other medical health recommendations and orders, then you can stay open for now. So people are getting really creative with this, as I said, and we don't know how it will fall out. But that's kind of my overview of some of the issues that I've been dealing with, and our firm has been dealing with most frequently, is these ideas of how to continue to support our employees. So I think I'll turn to Ari and see if there are any questions he wants to push to me.
You bet. Thanks so much. And this is a great overview, and I think it touches really so many of the topics of the questions that I'm already getting through the chat window and by email. And some of the questions have a very clear theme, and much of it has to do with lack of clarity, not a lot of information in terms of what the process is, what's next, and how to go about dealing with the various individual situations. I'm going to start off with one question that just came in, was more about EI benefits, whether the waiting period for EI is waived for everyone or just for those applying due to medical reasons.
So the waiver of EI in this case has been tied to people who are on the COVID-related EI. So if your business closed due to EI, if you're quarantined, if you're looking after someone who's ill, then it's waived. It does not seem to be waived for people across the board. So if you were a seasonal worker and you're drawing EI because your winter season just ended, then I don't think you will be getting that. The government has been tying it so far to the COVID-19 things.
Mm-hmm. And you mentioned just before the newly announced excuse me, the CERB, the Canada Emergency Response Benefit that was announced yesterday. Who is eligible to access that program?
Right. So that again is pretty broad. It's an emergency care benefit. So it's for people who are falling outside of a lot of the traditional EI. So it's in cases where you are actually home because your kids are off school, if you're home because you have to care for someone in your household, but it does apply very broadly across the spectrum. So in terms of who exactly can qualify for it, it's a fairly broad list, and I'm not going to pull up, but if you do look online, it does have in the government's website actually has a pretty good statement of who can qualify for it.
Thanks for that. And I just want to also point out that your firm, Greyell, has a really fantastic memo about that specifically that you published yesterday as well, that outlines some of the eligibility. And you can also find similar information about that on Engage HR's own website as well, through our COVID-19 resource page. I want to take you back. One of the questions relates to one of the topics that you touched, the new BC Employment Standards Act. So BC announced a new ESA COVID-19 leave, which provide job protected leave for those who are unable to work due to COVID-related issues such as illness, caring for an ill person, childcare, etc. Does this impact employers who have done layoffs for shortness of work due to COVID? And if so, how and what do they need to be aware of, especially when it comes to time to bring people back to work?
So the first thing to note is that this leave extends for as long as the situation extends. So in terms of how long the employer has to bring people back to work, it depends. Sorry for that answer, but it's very contextual to the specific employee and the specific employer circumstance, because the length of the leave depends on how long they remain eligible. So how long they're in quarantine, how long they're showing symptoms, how long they're caring for a vulnerable person, all of these factors. In terms of obligations to those employees who have already been laid off on account of it, if it was a full layoff, a termination, then there's the obligation on the employers to re-offer the employment if they were terminated for reasons that would grant the leave. So if they were terminated for COVID-related issues, then I think the employer does have that obligation to go back now and re-offer employment. And the odd result is that they would be de facto put on leave, the ESA leave, from the time they were terminated until the time that they accept the re-offer of employment, and then almost certainly be put on further COVID-19 related leave. Because of the possible impact on EI, I can see some employees not accepting those re-offers of employment, and they may prefer, in fact, to be terminated.
Great, thank you for that. Relating to that, there's been a couple of questions about employers' obligations towards employees on leave. One specific example question was, what happens in a case where I'm starting as a business person, I'm starting to bring back employees, but I found that my company is a bit leaner now and more efficient, does not need the same number of employees to come back. What are my obligations towards those employees who I may not be able to bring back?
Yeah, I think we're going to see a lot of change in the entire work world. People will get used to all of a sudden the fact that we can have more of our employees actually working at a distance. We might not need that same amount of office space. We may realize that, in fact, certain jobs were duplicating each other to a great extent, and we never noticed it in the traditional workspace. But now that we're actually having people work at a distance, we will notice efficiencies we can build as we are paring down our workforce temporarily. And so there will be a lot of questions with regards to what happens when this is all over and we realize we don't actually need to bring everyone back. And I think we are going to fall in the traditional layoff paradigms where somebody's job can be terminated because they are no longer needed. At which point you'll have to give them the standard notice or pay in lieu of notice. And that's where the employment contract will help define what conditions there are on terminating the employment relationship. But I think that's what it would fall into, is we're looking at a lot of people who will be found perhaps to be redundant, or simply the work has changed. A lot of people are innovating and changing not just the way they do business, but the business that they do. And so certain jobs may be eliminated, and then we'd be facing at the end of this a layoff for those people, which would be a classical termination.
And if I can just pop in there, Adam, I'm assuming that that would be the same associated with business returns, but economic conditions do not put my business at the same level of abundance that I had before. And so I have a shortness of work just because the business is not as large as it used to be.
Yeah.
Even though everything is, we're all back, it's all back to normal. So
yeah. And so this is where a lot of people are coming up with some more creative solutions. Some employers are trying to find ways of getting their employees to make sacrifices along with the company. So the employees will voluntarily take leave on the understanding that they will be hired back on a seniority basis or something like that when the environment permits. And the employers are often continuing benefits if the benefit provider will let them for that period of time. But that's exactly it. I think in the end, some businesses will have been really negatively affected by this and simply not have the income stream and the demand for their product or service that was there pre-leave. And so some of those employees will no longer have a job to return to. And that's going to make it tough because a lot of people are predicting that through the period of this, we'll see Great Depression level unemployment. And so we can't just assume in the end that everybody's going to go back to their job and we'll pretend that these months didn't happen.
Thanks for that. I think there's quite a few questions relating to this new BC ESA Act and leaves, and some of the questions are quite interesting. Before I ask my question, I wanted some really interesting clarification on the situation. What happens in terms of the decision-making process as far as who to bring back? How do organizations who don't have a seniority process in place or any other mechanism in place, how do organizations decide if we lay off 50 coffee baristas, how do we decide who gets called back first?
Yeah, I think it's tough because in a non-unionized environment, we don't usually think about that kind of thing. Who gets hired back first and in what order? And if we can only keep 30% of the pre-COVID workforce, who's that 30%? Are we choosing our cousins and their children, or are we going to be more equitable about it? And that's going to be something that each business will have to manage on their own. So it depends. But in this case, there are a lot of ways to mitigate the risks about choosing who to bring back, because you want to be abundantly clear that you have a process in place so that there is not a chance that discrimination is being one of the factors in who you're choosing to bring back. You would have to put I would suggest, a documented process in place so that it's not just you choosing all the people who are of the same linguistic and ethnic group as yourself. But in terms of how that's done, it will be really up to every individual employer to determine how best to manage that return to work.
Speaking of return to work, there's a couple of questions relating to how to proceed with individuals who are about to start a graduated return to work program or graduate return to work plan, and how does it impact those kind of mechanisms and scenarios?
Yeah, I think it's really interesting because a lot of the return to work and accommodations that are made in the workplace for employees might almost be made easier if everybody's working at a distance. If the person is still doing a return to work and coming into the traditional work site, then it might be harder because there might not be the supervision, support, management, and assistance there for them to accomplish. And that return to work will have to be reformulated. But if the return to work is giving the standard idea that there are various accommodations in place, that the return to work is a gradual return to work, so they're not working full hours, then that's still easy enough to manage at a distance. Because I don't have to put in 12 hours a day at my house. I can put in 3 hours, take a nap, put in another few hours, which actually sounds like a much better plan than what I've been doing. But I suspect that the real challenge will be communicating with the employees to ensure that they're comfortable with how the return to work is being managed. So because they can still do that gradual return, because it's not necessarily a gradual return to the work site, it's a gradual return to performing the job function.
Well, thanks for that, Adam. Good question coming in as well regarding remote workers. Are there any expectations for employers to cover or subsidize basic expenses regarding remote work, such as internet, hydro, etc.? Were you able to hear me, Adam? I think Adam perhaps is lagging a bit. Adam, can you hear me okay?
I can now.
Okay. Let me just repeat that question in case you haven't heard it. Had to do with remote workers and any expectations for employers to cover or subsidize some basic expenses like internet, hydro, etc. Any thoughts about that?
Sorry, you're talking about the employer subsidizing it?
Yeah, correct. For employees who are finding themselves now incurring some added cost in terms of staying at home, utilizing more hydro, internet, etc.
So traditionally, that's been offset by filing your taxes as having that home office. And so if my home office takes up 10% of the square footage of my house, I take all of the expenses for the house, the mortgage interest, the electricity, the heating, the internet bill, and I can write off on my tax. Have you all frozen again? No, you're just paying rapt attention. Okay.
Yeah.
So traditionally, it's been done through that process where if you're working from home, you already have advantage of those tax write-offs. If employees are suddenly being told, hey, you're going to work from home, and by the way, we haven't provided you with the equipment that you'll need, or your bandwidth on your internet traditionally is very minimal, but you're going to need more for work, then I think the employer would have an obligation to provide that to the employee as part of their office. So it's kind of a hybrid.
And Adam, would that obligation extend to, pardon me, employees who require some specific accommodation in regards to their health? For example, if they need a specialized equipment like a chair to support a nailing back or a specific keyboard to use, would employers be also required to ensure that the workspace that employees are utilizing at home adheres to that requirement?
So I'll go back to my falling down the stairs and my colleague cutting his hand on the knife while cutting an apple. WorkSafe is saying that if your home is your workplace, the employer has the same obligation to ensure that it is a safe workspace. So those same accommodations would have to be there if you're working in an office or if you're working at home. So if at the office I would be medically entitled to a sit and stand desk, then if I'm required to work from home, then I should have that same desk at home. This is going to pose a significant challenge because if you have 200 employees working from home, you're certainly not going to go and inspect every one of their homes to ensure that it is outfitted for safety and for ergonomy. But technically, that is where we are. So the employers do have that obligation to ensure that their employees, while working from their designated work location, have that.
Sure. Next question I have here is, if someone goes on a sickness benefit and then comes back and there is a shortage of work, would they be able to qualify for regular EI or for the emergency benefit? Or would they be disqualified due to 2 leaves in a row?
No, so EI and the benefits are completely separate. So you can and are in fact encouraged to apply for one then the other. So they wouldn't be precluded from doing that, the CERB and the traditional EI sick benefit. In terms of going from one EI to another EI, that can be more challenging. And I suspect that it's going to be an interesting question as to whether or not you can go from EI to CERB back to EI, or vice versa. And a lot of that will depend on the qualifying hours and the weeks. So, you know, you do have those 2 to play with, and I'd suggest that's probably where we are.
And with the government changing and adding new programs on a regular basis, it's very possible that we will be introduced to something new as well in the future.
Yeah, I anticipate, right? Because right now what we see is that EI will carry people for a very long period of time, and the CERB will carry them for up to 16 weeks. So the combination of those 2 will carry most people for a few months, you know, up to 6 months, relatively easily. Beyond that, we'll need more government legislation. So I think over the next couple months, the government will start to think about longer term. And we will, as Ara is suggesting, see more legislation continuing to come through to figure out how this is all going to play out in the longer term if we need more benefits.
Our next question is from Rose. Hi, Adam. We're going through layoffs for employees less than 90 days tenure, some for performance reasons. Are we obligated as an employer to rehire them?
So there is a time frame for people to actually qualify for this, and I think it might be 90 days, but I don't want to lie to you because off the top of my head, it's not coming to me. But there is a minimal time frame for that. Now, if you are laying people off for performance reasons, then you're not laying them off for a COVID-19 related reason, and you wouldn't have that obligation. If you're laying them off for a COVID-19 related reason, because that's just simpler than saying, oh, and by the way, you're a bad performer, you might want to go back to the you're a bad performer and we, given the climate, can't keep you on.
Understood. That question is, if we have an employee who is coming to the end of a maternity leave, will they be able to be covered by the emergency care benefit when their EI is over?
It's a good question. It seems that that would be the case because there are provisions in there for people who have been working for a set period of time, and it does have a big clause for if you were on mat leave for a period of that time. So it seems that they probably can, but again, there would be some, it depends.
Mm-hmm. Somewhat related to that, a question about what will happen to business owners who may end up shutting their doors, but currently have employees on leave, such as mat leave or COVID-19 leave. What happens to those kind of employers?
Yeah, there are already things in place so that if somebody loses their job because a store shuts down while they're on mat leave, then clearly the employer top-up is going to be challenging if the employer has gone bankrupt. But they still carry on the mat leave EI. And then in the end, there are a whole lot of programs available through the government. They have been available for quite a long time for people to obtain retraining. In fact, traditionally, I haven't looked into it in a while, but usually if you lose your job while you're on mat leave or you're unable to return to it because the job has gone by the wayside, you can qualify even for, I believe it was 2 years of paid higher education. So there are a lot of benefits out there through the government for people who may lose their job in that circumstance. So I don't think that you're currently at a disadvantage, except that it might be more likely that there is not that job to come back to.
Just a follow-up question regarding the ergonomics and employers' responsibility. In terms of what is reasonable for employers or expectation by employees for employers to take in terms of their new office space. In this particular case, there's a staff of 35 office workers who are all working from home right now in support of the government's request for COVID-19 self-isolation. They got no idea how long this is going to be before they return to the office. What is reasonable in terms of what the employer's responsibility is about ensuring that employees are working safely and comfortably from home, especially given the unknown length of time that this will take?
Yeah, and I think this is where we see practicality meeting with idealism. The WorkSafe BC is putting into place what should be done, but sometimes we have to settle for what can be done. And so for an employer to perform tasks for supervising and inspecting workplaces and supporting employees in their workplace that would cause an undue hardship, we're still at the same test of accommodation that we've always had, that you would no longer be required to accommodate because it is an undue hardship. So can employers claim that it's an undue hardship to check out and outfit every single home office? I think that would be a challenge because that's really, you're making a business case against accommodating and you'd have an uphill battle. But in terms of what can realistically be done, I think we have to expect some leeway in there. So while my employer should probably be making sure that the home renovations that I did to build my office are not going to cause it to fall on my head or me to get tetanus, I realistically don't expect them to do that, but it's a risk, and it's risk management. So employers will have to gauge that risk and how big a risk it is to have their employees working from home, and whether or not they need to perhaps get access to their work site in order to remove various objects, desks, chairs, and provide them to their employees so that they can have that properly outfitted home office. And I think that's probably what we'll see if this goes on for months, that a lot of office spaces will start to be emptied out, and employees will have that office equipment in their home because it's not helping anyone at the office. And it's going to help ensure that they are better equipped and safer in their home.
Just staying on that theme very quickly, is there any specific provisions or accommodations that employers needing to do in regards to employees that are now working from home and are also taking care of young kids, or perhaps the elderly? What are the employer's responsibilities in regards to those employees?
Yeah, it's really challenging right now, and that's one of the reasons for some of the new leave provisions is the recognition that some of us have competing obligations, and when you see a change in that workplace requirement that creates a substantial interference with that family obligation, then in order to say, sorry, you're fired, you're getting into the family status discrimination area. So you're going to want to be really careful with how you manage those employees who are telling you, look, my kids are out of school for the rest of the year and I need to deal with them because frankly, daycares aren't open for anyone except the essential service providers in the medical realm and the first responders. So I have to care for them because my kids just can't run feral. I think you will see a lot of people also saying, look, our generation has taken in our elderly family members. I inherited my father-in-law a few years ago, and he is self-isolating in a different part of our house. But if he were a little older and we were actively providing care for him, it would provide a real challenge for us because we'd have to choose between whether or not we have the time and energy to look after our children and our family members, or if we want to put that time and energy into the job that we have traditionally been paid to do. So it's a tough balancing, and I think that we will see a lot of people applying for the unpaid leave or agreeing with their employer to take that temporary layoff with various understandings in place in order to provide for their family.
Thank you for that, Adam. Question from Leslie regarding the new ESA leave of absence. Mm-hmm. Does it also apply to leaves due to temporary shortage of work, e.g., is it possible less restrictive replacement for a layoff?
Can you say that again?
Yeah, the new ESA leave of absence, does it also apply to leaves due to temporary shortage of work? For example, is it possible, I'm going to paraphrase that or read exactly what Leslie says, less restrictive replacement for layoff? I guess it has to do with the shortage of work as opposed to COVID-19.
Yeah, I think if it's a COVID-19 related shortage of work, and a lot of things can really be drawn to that right now, you can fairly generously suggest that if there is a shortage of work that happened on or after March 27th, or January 27th, sorry, because we're still only March 26th, on or after January 27th, if there is a shortage of work, you can probably suggest that it was COVID-19 related. If it is absolutely clearly not COVID-19 related, then I think you're going to have a more of an uphill battle trying to apply some of these new provisions.
Interesting question from Rose. Can we rehire employees and shorten their hours or offer them commission-based income rather than salary-based income? Essentially changing the employment relationship.
Yeah, so it's one that a lot of employers have been looking at. People are looking at work sharing programs and looking at reduced hours or commission based income as Rose suggests. And those are really great options if the employee is willing, in order to make sure that the contract is valid. In order to change it, there has to be consideration. So the employee and employer each have to give and get something. So it can't just be the employer saying, hey, here's your contract. It says you get 40 hours a week, but we're gonna say that we can still pay you if you do 20 hours a week. The employee isn't getting anything other than getting to work, which they had in the first place. So you have to be sure that you're giving them something new. And that's one of those funny nuances of contract law that gets really complicated when people start litigating after the fact that, well, I should have been entitled to more hours, or I shouldn't have been laid off from this job or reduced in salary from this job because the contract wasn't legitimately put in place because there was no consideration flowing each way. So that's the long answer. The short answer is, if you're looking at changing your employment contracts, a lawyer is your best protection.
Mm-hmm. One other question that's interesting is, how does the top-up work, the employee top-up? Where employees can go on EI and employers would top up a salary. How does that work? And how does it impact employees and their return to work as well?
Okay, so the sub plans that I've talked about before is that top up, the supplemental unemployment benefit. And it's one of the few options to avoid a clawback for the employer. But once the employer has that in place, it's not particularly flexible. So you need to be careful. If you want to have your sub plan topping up employee benefits to 80% while they're on EI, sick leave, or various COVID-related EI benefits, then you need to be careful that you're not going to want to change that partway through. How to apply, it's actually fairly straightforward, and I've been seeing that people are getting relatively rapid turnarounds through, I believe, CRA. So the application process seems to be relatively straightforward. Turnarounds seem to be relatively rapid because the government realizes that this is actually going to keep people afloat. But the actual application process and the nuances of it, I'm afraid I am not super familiar with.
If an employee agrees to reduced hours, is consideration still required?
So you're getting into a lot of nuances of contract law, and oftentimes what happens is you see that the employer has all the power because the employer is controlling that work relationship and whether somebody gets paid or gets fired. So if the employer says, if the employee comes and voluntarily says, look, I'd like to do reduced hours, then you can put in place a new contract for reduced hours, but you really want to cover yourself to make sure that there's no suggestion that the employee felt pressured to take that agreement and give up some of their rights because they're the ones who don't have the power in this.
Some additional requests for just a bit more clarification in terms of the protected leave and EI and eligibility. One of them really has to do with, if it's a protected unpaid leave, it's unclear if people will be able to collect EI benefits while on it versus being on temporary layoff in order that they can collect EI.
Yeah.
I guess the question is, if it's a protected leave, are people still able to collect EI?
No. My understanding is that if you're on this new COVID-19 related leave, you do not collect EI. So the issue is during this unpaid leave, what happens? Well, your work is still guaranteed to you. Now, I'm hoping that I'm mistaken in that, because it does seem really peculiar that people would be going on this COVID-19 related leave for as long as the situation exists, but not entitled to EI. But that is my understanding of it.
And is it fair to also say, and this is also a question for me, individuals who do not qualify for EI, generally speaking, would qualify for the CERB?
Yes, I mean, if you are leaving your paid work on account of COVID-related things, so the voluntarily leaving your work, usually you can't get EI if you're just choosing no longer to go. However, the CERB does allow for a lot of circumstances where you're choosing, and I'm putting choose in air quotes because really looking after your family isn't much of a choice. But if you're choosing to leave for some of those reasons, then you could get it. And that's one of the benefits. Again, it's the difference between that 13-week temporary layoff and the indefinite COVID leave. That, you know, one of them you absolutely are still employed, the other you're on a layoff.
Mm-hmm. Well, I think there's certainly still a lot of exploration to do in terms of how these new regulations, those standards interact with one another, how specifically BC ESA and the federal new programs all kind of work together. And I think that many of us are still trying to figure this out.
I think so, and I'd like to see a lot more clarity come out on how this all meshes together, because right now most of us are just looking at it and taking that square peg in the round hole and just whacking it really hard until it kind of lodges in there, and the little pieces that break off we'll just glue back on after.
Absolutely. We're at 2 o'clock, so we're just about done. It's amazing how quickly an hour goes by when you're paying rapt attention to some really great questions, some really fascinating situations, and as you mentioned, sometimes the answer is it depends. So certainly for if you want some more in-depth advice to your specific unique situation, I know that Adam and his firm Worker would be happy to help you, as is Engager. Obviously, we're here to help you as well with anything that you need relating to your workforce planning. I want to say thank you to all of you for attending, and especially for Adam for agreeing to share an hour with us and share his wisdom and expertise with us. Just fantastic to be able to do that, to offer that free to our community. I think this is wonderful. So if you were in place, I would ask everyone to give you a big round of applause, but we'll give you a big virtual round of applause and say thank you.
Yeah, can I just jump in there? I'm just watching the texts go, and
Please.
One of the things, the COVID-19 leave, I've said you won't get EI, but it looks from my reading of it, and I want to be clear on that you should still be able to get the CERB. So for that period of the COVID-19, you're not completely locked out, because you should be able to get the CERB if you're on that COVID leave.
That's great clarification. Thank you. I think it is an indication of the federal government trying to make sure that everyone gets something, or there's a system in place for just about any situation. It's likely that some things are going to slip through those cracks, and we'll try and catch them as they can. But right now it seems like there's 2 systems in place, one for those who qualify for EI and one for those who qualify for the CERB. And there are some individuals who qualify for both, but they cannot have both at the same time. They have to choose one or the other. Mm-hmm. I also want to just remind everyone that the recording of this session is going to be is taking place. We're going to have that available for you to watch it and share it with your friends if you wish. We'll be sending a link to that later this afternoon or first thing tomorrow morning to everyone that's attended. And I just want to say a huge thank you to Adam and to my partner Denise for being here and helping support this event, and to all of you for taking taking the time from probably what is a very busy and hectic day, even though you're at home, to share your experiences and ask those really profound questions, and hoping that these were of help to you. We will likely hold something similar in the future, so do keep an eye on our webpage on engagehr.com and the COVID-19 page. And of course, Rupert Greyell, who's the premier labor relations firm in BC, will be happy to help you as well with any of your needs too. So I just want to say again, huge thanks to Adam, big round of applause to him and to all of you. And I hope to see you again very, very soon.
Thanks for putting this together, Ari and Denise.
Thank you so much, Adam. It was great. Yeah, good job.
Thank you, everyone.
Thank you so much.
Have a good rest of your day.
Thanks, everybody.
Bye all.
Bye-bye.
Bye-bye.